This is my iPhone, and this, as you can see, is the App Store. At the moment, the App Store made by Apple is the only way that you can download new apps onto your iPhone. This is Spotify. Spotify is a music streaming service that competes with Apple's own music streaming service, Apple Music. At the moment, you cannot subscribe to Spotify's premium service from within the app. You must actually go to your computer, pull up a browser, log into Spotify.com, and purchase a subscription that way. Why is that? Well, the reason for that is the so-called Apple tax. Apple charges its app developers up to 30% of every purchase transaction made on an iOS device. That would include a subscription to Spotify Premium or Netflix, for example, or dating apps like Match and Tinder, and even video games like Epic's Fortnite. This has obviously led a lot of app developers to complain about Apple's unfair competition and accuse Apple of having a virtual monopoly on iOS devices. But changes are coming soon to the iPhone. Last September, European Union or EU lawmakers responded to these complaints by telling Apple to tear down its walled garden when they passed the Digital Markets Act, or DMA. The DMA requires digital gatekeepers like Apple to allow third-party app stores and payment processors. Let's take a look at some of the relevant provisions of the DMA. So as you can see here, this is Chapter 3, Article 5, and then scrolling down to paragraph 3, the gatekeeper shall not prevent business users from offering the same products or services to end users through third-party online intermediation services, that would be app stores, or through their own direct online sales channel at prices or conditions that are different from those offered through the online intermediation services of the gatekeeper. In other words, the Apple iOS operating system must allow third-party app stores onto its devices. Paragraph number 4 states, the gatekeeper shall allow business users free of charge to communicate and promote offers, including under different conditions, to end users acquired via its core platform service or through other channels, and to conclude contracts with those end users, regardless of whether for that purpose they use the core platform services of the gatekeeper. Paragraph number 5 here states that the gatekeeper shall allow end users to access and use through its core platform services, content, subscriptions, features, or other items by using the software application of a business user, including where those end users acquired such items from the relevant business user without using the core platform services of the gatekeeper. And then interestingly, down here in paragraph 7, this is the paragraph that allows for third-party financial processors onto iOS devices, thereby bypassing the 30% Apple tax. It states that the gatekeeper shall not require end users to use a payment service, such as payment systems for in-app purchases of that gatekeeper. So in other words, Apple no longer can require that every purchase transaction on the iPhone be through Apple's own proprietary financial processing service, and instead you can use third-party processors like Stripe. If you want to read that law for yourself, then I'll link to it in the description below. So what does this mean for the consumer? Well, this law means that Apple will have to allow third-party app stores in iOS devices. It also permits sideloading, where users can install software downloaded from the web. Now, Apple has rightfully and understandably raised security and privacy concerns over these new features or these new laws, but it is what it is. Apple will have until March of 2024 to begin complying with the Digital Markets Act. According to recent reports from Bloomberg and other sources, Apple plans to comply with the Digital Markets Act when it takes effect in early 2024. Some have speculated, however, that Apple will only roll out these changes to users in the EU where the law applies, meaning iPhone users in the United States won't see them. But not so fast. Could we see a law like this passed in the United States? Well, maybe. A bill known as the Open App Markets Act is currently making its way through Congress In February of 2022, the Senate Judiciary Committee advanced the Open App Markets Act in a 20-2 bipartisan vote. A similar bill, known as H.R. 5017, was introduced in the House in 2021. It's currently pending and it appears to be stalled in the House Committee on Energy and Commerce. The bill is intended to protect the ability to sideload apps and prevent operators of app marketplaces like Apple's App Store from self-preferencing their own products. So it's safe to say that lawmakers in the United States will be watching the European Union roll out this law in 2023 and then into 2024 very carefully to see how it all plays out. If Apple's implementation of these changes in the EU goes well and is well received by the users of iPhone products in the European Union, then the Open App Markets Act in the US may gain some major momentum. If you don't want to miss any new developments in this story, then make sure to hit that subscribe button below and turn the bell notification icon on. If you like this video and you'd like to see more videos like it, then hit the like button below and leave a comment. And of course, as always, thank you for watching.